I want to welcome everybody to February the 1st at 2 o'clock. The notice was given out of the committee meeting for the Tennessee Board of Accountancy. We're meeting here at the Davy Crockett Tower, conference room 1A in Nashville, Tennessee. We're also meeting virtually. We have some members that are virtually meeting. Normally for this meeting, we do not do a roll call, but we're going to ask Karen to do us a roll call and first do a roll call for the virtual meeting board members that are with us today.
Larry Elmore. Rob Vance.
Here.
John Griesbeck.
Here.
All right. Next, I'll ask for a roll call for all present members here today, board members.
Here. Here.
Here.
Present.
Sam Bennett.
Here.
Brad Floyd.
Here. All right. Thank you, Karen. Today we're going to have committee meetings from the Enforcement Committee and also the Executive Committee. In addition, we're going to have a public comment period at the end when we get to that point. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheets or by placing your name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for the other speakers. So if you're online virtually and you want to make a comment, when we get to that period, please put your name on the chat box. All right? With that, I will say that we're set to go. The first thing on the agenda is enforcement, and Mr. Monroe, Chairman, you're up.
Thank you, Andy. 2 items here. First is the case and complaint report, which is just a one-page report in our read ahead that summarizes the active or open complaints at this time. It does not include the complaints that are on the legal report that we'll be considering in just a moment as the Enforcement Committee. I think the thing of note from this report, if you look down at the bottom, the complaints opened by year. Back in fiscal year 20, we had 93 complaints, and then they seem to have dropped off during the COVID era. Whether that was a causal factor or not, I don't know. But so far for fiscal year 24, we have 63 open complaints open this year versus 62 in all of fiscal year 23. So I do know that in some cases, and particularly with one case that we'll be discussing later today, there are approximately 20 complaints that are affiliated with one individual and related firm. So that might skew the numbers as well. This is just an informational item. Next, we'll go on to the actual legal report. We have typically discussed these cases by bucket, if you will. The first bucket being the consent agenda, where there is either no action or closure recommended or a letter of warning. The second bucket is where discipline is proposed. And the third bucket is where we have a representation of a previously presented case due to new information coming to light. And we have cases in each of those 3 buckets. We'll go ahead and start with the consent agenda items, which are item numbers 1 through 8. Based on discussions I've had with Neil, it's been noted that there is not a requirement to read the long or lengthy case numbers into the record for each of these cases.
Thank you, Neil.
So the cases that we have in the consent agenda item, the very first case is a recommended disciplinary case of closure. This involves an HOA, a complaint associated that the respondent did not provide the appropriate service for an HOA. Once that was investigated, it was determined that there was no sufficient evidentiary basis for that complaint, and the recommendation is to close it. The second item is with respect to, it has elements of a complaint about late filing of returns, and also effectively a billing dispute. Billing disputes are not within the board's jurisdiction. And with respect to the other element of the complaint, that based on investigation, the nature of the evidence was not conclusive enough to establish any violation. Therefore, the recommendation is for closure. The third case is also relating to due care and professional competence. It is also recommended for closure due to lack of sufficient evidentiary matter.
Janet Booker Davis is now joining.
Welcome, Janet. This is Kevin Monroe, and we're just going through the legal report, and we're just summarizing the cases or items that are in the consent agenda part of the legal report.
Okay, thank you, Kevin. I was watching on the website, so
okay.
I've been keeping up. Thanks so much.
You're so welcome. The next item, case number 4, is a case concerning the use of accounting in a business name where it was not appropriate to do so under our board policies. The recommendation here is for a letter of warning. The mitigating factor here is that the respondent was very cooperative once this was brought to their attention and took timely steps to deal with the matter, and therefore no civil penalty is being recommended in this particular case. Items number 5 and 6 relate to a case that the board has discussed earlier, and that was with respect to a situation where there were allegations that employees of a large firm were inappropriately passing on answer keys for internal web-based training types of elements. And in our prior deliberations, the board determined and asked staff to follow up and investigate on 2 employees that were alleged to have passed on a significantly greater number of these so-called answer keys to others than the other members that were involved. I think there were probably over 20 members that had Tennessee licensees that were involved in this particular episode, but 2 of them had by far and away allegations that they had passed a significantly greater number of answer keys on. And so staff did follow up with respect to these 2 particular cases, had an investigation. I believe at least one of the respondents was represented by counsel. I don't know that the other one was. They both were? Okay. So those meetings were had and discussions, and ultimately what it came down to was that in the one case, the alleged violations occurred before that individual became a licensee. And in the other case, the vast majority of the instances that occurred also occurred before that individual was a licensee. And so you'll see in the detail here that, you know, our authority is specific. We can discipline licensees on this type of a violation. But if they're not a licensee, we don't really have a jurisdiction. And so effectively, the recommendations are in the one case closure because there were no instances of potential violation while the person was licensed. And the other is a letter of warning to address the one instance that did occur while the individual was licensed. And as you see in the case background, that one individual effectively was terminated. Her employment was terminated by her employer as a direct result of the consequences of these actions. And so, you know, that's where the recommendation stands with respect to that. And then I'll read through the remaining 2 consent item agendas, and then we'll circle back for any discussion or questions that anyone has. The next case is a client's records case where there was an allegation as to whether records had been taken and or returned with respect to the complainant, and there was insufficient evidence to establish that there was any violation there upon investigation, and so the recommendation is for closure. And the final case is with respect to a complaint concerning due care. This involves a data entry error that resulted, I believe, in a tax return that need to be amended. And so the recommendation here is to deal with that via a letter of warning. So those are the 8 consent items. Are there any questions or comments on any of the 8 items, or any questions for me or for legal and staff? Wendy?
Larry Elmer has asked a question regarding case number 1. He is asking to clarify, the first paragraph indicates that there's an audit required, but the last paragraph says there's not. I believe the first paragraph is referencing the allegation, and the final paragraph is referencing that after the investigation, it was determined that it wasn't necessarily an audit that was required. But I can let the two of you.
That's absolutely correct.
Okay.
Hello, this is Janet. I had a question.
Yes.
On 5 and 6, does anybody have a note of when we reviewed those 2 cases originally in the board meeting?
This is the first time these are coming before the board, Janet.
I thought this one related back to where we had opened investigations for 2 people of several that were involved in the CPE key sharing.
Yes. We believe,
and we had reviewed all those other cases before, and I was just wondering when we reviewed those cases originally.
we believe it was the May 2023 meeting.
May 2023. Okay,
Yes.
Thank you.
Uh-huh.
Yes, and at that time, Janet, we had made a decision that we would proceed with further potential investigation of just these 2 because they had been alleged to have shared answer keys more frequently by a multiple factor versus the other individuals that were alleged to have been involved.
Yes. Yeah, I just wanted to go back and review my notes from that prior meeting, but I was okay with the recommendation.
Okay. Thank you, Janet.
Okay, thanks.
If Duke might be able to help us, Larry is still has a question on number 1. Back to number 1, he says the first paragraph says that the bylaws were referenced. It says that the bylaws say that. Doesn't say the complainant said that.
That's the bylaws. And that is where, that's where it's in.
No, it's just not.
Oh, okay. Is that the question? That the HOA bylaws do state that an audit of accounts at the association shall be made annually by a certified public accountant.
So I think what he's questioning is that he's trying to clarify, did the bylaws say that an audit was required or not?
I believe it did, but then respondent clarified, though, when there was not enough information with the HOA president, and then the HOA actually took a vote on it,
I think I understand the question. The first paragraph states that an audit of accounts of the association shall be made annually by the CPA, and then the next to the last paragraph states the bylaws do not require a full financial statement audit. So I think Larry is saying that those 2 may be in conflict. What appears to me is that the homeowners decided, no matter what the bylaws say, we don't, or the CPA, we can't do an audit of these records.
That's correct. That's exactly what happened. Was there was supposed to be an audit, something happened because they're transitioning from one finance company to the next, and records were misplaced or stolen or lost or whatever it was, and they could not actually conduct an audit based on the evidence that they had at that time.
So Larry's, and I understand it, and that sounds correct to me. I think Larry's issue is the sentence in the next to the last paragraph that says the bylaws do not require a full financial statement audit.
Hey, this is Rob Vance. Sounds to me like this is a classic misuse of terms by non-accountants in the bylaws. Perhaps it said that it needed a financial audit, but it really wasn't that way. Just a comment.
Thank you, Rob.
Larry is suggesting maybe we remove that sentence.
Just rely on the fact that the homeowners association voted to step the bylaws and do an agreed upon procedures.
It is the sentence in the next to the last paragraph, and it's the sentence that says the bylaws do not require a full financial statement audit. Here, just about 4 lines above the recommendation line.
I don't have any objection to removing that sentence. We can make a note of that.
Thank you. Any other comments or questions on any of the items 1 through 8 on the consent agenda?
Mr. Chairman, case number 5, and I agree with the recommended letter of warning, but the 4th paragraph, I think the board had a question about the genesis of the answer sharing, and the information says during the investigatory interview with her attorney, respondent was adamant that any answer key sharing was done under a collaborative, inclusive environment pushed down from the partners. Respondent was encouraged to assist her co-workers when they were struggling with material. The message from hire was to push through the CPA so employees could get back to working on audits. And all those we had questions on when we were reviewing the earlier reports. So.
Noted.
Yeah, this is Rob Vance. I think that's the first we've heard of that. If I'm correct about the partners being involved, or am I incorrect?
Well, I think more broadly speaking, when we initially discussed the case against the CPA firm, and also in the context of the PCAOB's investigation and ultimate citation of that firm, there were at least it was an open question as to what degree senior management of that firm at the national level was involved. And the PCAOB, to my recollection, did not assert or was not able to prove that there was such high-level or national involvement, but I don't think it addressed necessarily involvement of local office management. It did indicate that the vast majority of the so-called perpetrators who were sharing the answer keys were generally manager and below related younger staff.
Right. I remember the question coming up, though, was this some sort of mandated or quote-unquote recommended practice from the owners, the partners? And yeah, I think we didn't know that. I note that in the next case, number 6, that person still works at the firm, and this subject didn't come up, which I thought was interesting. It's not, at least I don't believe the partner issue was mentioned in the case number 6.
Right, and Duke, you may want to address this, but I believe the first case, the individual involved was at a manager level. In the second case, the individual involved was somewhat less senior. Is that right?
That is correct, yes.
Okay.
Any other comments or questions on any of the cases in the consent agenda part of the complaint report? Lindy or Karen, any further comments from Larry?
No, there are none.
Okay. With that, then I would propose a motion that we accept the recommended discipline for each of the items 1 through 8 in the consent agenda item for the legal report.
That with the motion or with the change made by Elmore?
Yes, and to include, at least in the description background, the change relating to the sentence, striking the sentence about the bylaws. Yes, thanks for that clarification, Neil. Is there a second?
Second.
We have a motion and a second. Is there any further discussion or comment? Karen, will you please call the roll, since I think we've got members both virtual and in attendance?
Evan Monroe.
Aye.
David Crenshaw.
Aye.
Larry Elmore.
Votes aye.
Greg Gilbert.
Aye.
Rob Vance.
Aye.
Thank you. That motion passes. The next batch or bucket of cases are cases where actual proposed discipline is being recommended. And we have 4 different items in this particular bucket. I'll note that on item number 12, there are approximately 20 some odd complaints relating to the same CPA and that CPA's firm that we'll address collectively together. With respect to case item number 9, we have a situation where the complainant alleged that the respondent violated her duty as a power of attorney by misusing funds. Essentially, the respondent did not file a response to the complaint in probate court, and a default judgment was entered earlier in 2024. A hearing is scheduled for later on in this month in 2024, where potential damages against the respondent will be assessed. Due to the ongoing litigation, the recommendation here is that this be placed in litigation monitoring. It should be resolved hopefully by our next meeting, and then if there is further need to pursue discipline, we will do that. Case number 10 involves the unauthorized disclosure of client information. This is a case where, given the facts and so forth, ultimately, the information, confidential information of 3 clients was inappropriately given to another client in error. And at this point, an investigation was performed, and the recommendation here is in this particular case that we have a $1,500 civil penalty authorizing a formal hearing with the authority to settle via a consent order upon the respondent's payment of a civil penalty in the amount of $1,500. There was a mitigating factor in that the respondent did admit to the improper release of the records and has never had a prior disciplinary complaint before this investigation. So essentially, it's a $500 violation for each of the 3 client records that were inappropriately disclosed. The next item is with respect to operating without a firm permit. In this particular case, a client or a firm was soliciting clients and offering services without a valid permit for about a 3-week period of time. The complaint bears this out. There was a mitigating factor here that the respondent was cooperative and that the violation timing was only 3 weeks prior to obtaining a valid permit. And so therefore the recommended penalty here is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $650. And finally, the last case in this batch, or cases, I should say, involve 11 complaints against a registered accounting firm and I believe 8 complaints against the certified public accountant. And to summarize the complaints, essentially it is that the respondent had undertaken to perform professional work, primarily tax work, and had not followed through on the completion of that work. And secondarily, that in many instances, the respondent had actually solicited money in the form of loans from these individuals or clients, promising high rates of interest, and failed to repay on schedule, in many cases, some or all of the interest of the loans and some or all of the principal of the loans. I think, as I understand it, there is the potential for further federal and other criminal proceedings with respect to this matter. And let me indicate also that there is one recommended case. Among these complaints, there was an anonymous complaint that did not provide any substantiating information. That was case number ending in 63471. So the recommendation for that part is to close that complaint. But with respect to the others, the recommendation is going to be authorizing a formal hearing with the authority to settle via consent order upon the respondent's agreement to have his individual CPA license and firm permit revoked for a period of not less than 5 years. Respondent must agree that he shall not apply for reinstatement until at least 5 years have passed from the date of revocation, and that he must appear before the board in person upon any request for reinstatement. The rationale as provided by staff was that the sheer volume of complaints, along with the demonstrated pattern of similar misconduct and respondent's failure to answer the allegations, caused concern from a public protection standpoint. The respondent has declined to make a statement or sit for an interview with the assigned investigator due to the advice of his counsel, asserting his Fifth Amendment rights due to the ongoing federal criminal investigations into his conduct. He is not only facing pending federal investigations, but also facing other civil actions and lawsuits concerning these matters. As of January 2024, he has voluntarily closed a CPA license with the board, and his attorney has indicated that the respondent is willing to surrender his license. So this is a serious discipline, but also a very serious set of complaints and information. Neil, any additional information you'd like to share?
Just wanted to add that for some of the loans, they have not reached their maturity date yet. So you can't really say, well, the maturity date wasn't reached because we're not there yet.
Yeah,
but there
okay.
were supposed to be scheduled interest payments made. And on the ones where the maturity date has not been met yet, those interest payments for at least some period of time are behind or have not been made. Is that accurate?
Yeah, so generally speaking, most of those interest payments ended about August 2023. And so those have been in default for 5 months now.
Since around the time the respondent closed
his firm.
Right. And then on top of that, with any of those that were still, any of those loans that were mature and were due, none of those were paid back. So those principals have not been repaid.
That was a question that I raised with counsel as I was reviewing the draft of the legal report. And my initial question was, well, why isn't there a proposed civil penalty? And counsel had a thoughtful response, and that was that at this point we have a number of the complainants that are left holding the bag, literally, having had lent money and not proceeded. There are civil claims against that complainant, against the respondent, trying to seek back whatever assets are left from the respondent. And the notion was, is it fair and appropriate for us to seek a civil penalty that would in essence diminish the potential resources, if any, that could be left for the actual victims to seek? That was, I thought, a pretty appropriate rationale for not seeking a civil penalty.
I have questions from Barry. I'll stay on this number 12 since that's the one we've been discussing. He is asking, can we go more than 5 years? Can we bar him forever? Are his two questions.
Okay.
Tricky one. Our relevant statute is 62-1-111, which deals with revocation. So it says, after notice and hearing pursuant to 62-1-120, the board may revoke any license issued under, and it lists the statutes, or corresponding provision of prior law, may suspend the license or refuse to renew the license for a period of no more than 5 years. So to be safe and make sure that statutorily we're in compliance, I think there are arguably different ways that that could be interpreted on the 5 years. So to be safe and ensure that we're in compliance with the statute, that's where the 5 years recommendation comes from. But keep in mind, all we're doing is saying no, at least 5 years. And if he applies for reinstatement, that doesn't mean that the board has to reinstate him. We're just saying that he has to be revoked for at least 5 years and cannot apply for reinstatement until 5 years have passed. And then we're requiring an in-person appearance upon any request for reinstatement. So it would still be within the board's discretion. So that's why the recommendation is the way it is.
Thank you.
Chairman, I've got a question for Neil. If we were to consider penalties with this, monetary penalties, and then not with the intent that we can only go 5 years, but the monetary penalties probably will still be there in 5 years. Would that be something logical to consider? Because I really, what bothers me is that we have all these violations, and we had, I don't want anybody else to come back and use it against us to say, hey, you didn't penalize this person. Secondly, I don't want, if for some reason this person wins a jackpot and comes back and says, I'm going to settle everything, I want to make it whole, I don't think that anybody who's done some of this, although the allegations are there from the complainants, but should get away without having a monetary penalty, period. And we kind of have said that in a couple of cases in the last 12 months. So we thought that, we had to have a monetary penalty for each violation. So that I know that we don't want to block or keep somebody who has had money taken. If there are any resources, I think that they should have first rights. But is there any way we can put that out there so that if he does or she does come back, that at least we have that to fall back on before you even come to the board? You got to settle this.
Maybe stay is that the right term in the legal world? Stay any kind of civil penalty until requesting reinstatement, and if
I want to make sure I understand I don't think I understand the question. When you say keep it out there as far as the civil penalties.
In other words, not try to put the civil penalties out there, but not try to collect it until all the other cases are solved. Or at least they're litigated and the rightful people who actually lost, the citizens of the state who lost money in this case, that they got their civil penalties or their proceeds that they loaned back first.
I have a question related to this. This is Rob Vance. What kind of priority would we have if we assess a fine? Are we high on the totem pole or low in terms of all the other claims that he may or she may have against him?
I don't think that there's necessarily an order of priority that we would be in. I mean, there are going to be either he pays it or he doesn't if you assess a civil penalty, and if he doesn't, then it goes to collections, and then that's going to be sorted out through the process along with however many lawsuits there are. There are already lawsuits, is our understanding, and there are more to come from these victims to try to get their money back. And if it goes to bankruptcy, I imagine that would be sorted out through the bankruptcy process. That normally there's a scheduling order of who has priority. I wouldn't be able to tell you that what that order would be, but to get back to your question, Mr. Chairman, I don't know of any means to effectuate what you're talking about. I would have to research that further, honestly, because I don't know of any. I don't know if the board has done that before. I would be interested to know if it's been done. I don't know by any means by which you could kind of if I'm understanding correctly, assess a civil penalty, but delay collection on it until we determine what has been paid out, if anything, through the civil process, and whether any money is left. I don't know off the top of my head whether there's a way to practically effectuate that.
Well, I guess how I came up with that thought was when you said that, hey, we're probably not going to get anything, that if we do get something, we could get something from people who had lost money that have already have some kind of civil penalty against them or court appointed engagement there. But from my seat, I'm not letting this guy off or this gal off. I mean, I think that we should assess penalties for each violation. I just don't agree with that. And if based on what you just said, I think we should do it, if nothing else, just to say that we as a board are not going to stand for that. Even if they have to come back in 5 years, I mean, we need to document the fact that we had a violation of law and we assessed the penalty.
Yeah, the rationale again was simply, with the revocation, it essentially, I think about the term disbarment in the legal world. Right? Revocation, disbarring, the equivalent of a disbarment, basically. You're expelling someone from the practice of the profession. Very adverse kind of consequences and inferences that go along with that. A very serious penalty in and of itself, being revoked, being expelled from being able to practice. So that is a deterrent factor. And then looking at the fact that, and we all talked about this, but that is in itself a huge deterrent. And so, is a civil penalty really needed in light of the fact of that, and on top of the fact that you've got multiple victims here that need to be made whole, and whatever money is left, trying to make sure that it's available for them to recoup through the civil process. That was the rationale.
What about Wendy's suggestion that we level the penalties, but not somehow word it so that we don't collect until if and when he applies for reinstatement? Could it be a condition for reinstatement?
I'd have to look into that and get back to you. I really, and we can do that now if the board wants to, if the committee wants to take a recess, and I can do some research on that. I just don't want to speak off the cuff on that. That's not something at all in our conversations that we had even contemplated as a possibility.
Might that take a while to research? It sounds quite different.
Yeah, it does. It could. Staying the civil penalties until he applies for reinstatement, and then if you were to grant reinstatement, require him to pay the civil penalties to be reinstated. Is that?
Either that, or another thought might be assessing the penalty but agreeing to stay it if he permanently revoked his license.
Kind of does the same thing, doesn't it?
I'm just offering up options, but yeah. What we're doing right now is we're trying through a consent order to finalize this and not go to a hearing.
Hey, this is Rob. Wendy, I like what you're suggesting, because ultimately, I think the goal would be to have him removed as a licensee, and if he would, rather than get money from him, so if he were to revoke his license voluntarily, I think that's, I think maybe Neil said that's the ultimate penalty, if he were to agree to do that.
Question for you, Mr. Chairman. Because I agree with you on the seriousness of this, if he agrees to revoke his license, but then ultimately applied for restitution of that license, could we then, of reinstatement of that license, at that point in time, could we request restitution or impose a fine?
I don't think there's a means to do that, because a civil penalty, that's going to be, that's a form of discipline. So, I don't think that would be a proper function of a civil penalty, to assess it upon that would essentially be the equivalent of like a fine or a fee or something for reinstatement, and we don't have the board doesn't have the authority to levy anything like that. So I don't think I would recommend that.
So if there's financial penalty, it needs to be now as opposed to at the time of an application for reinstatement.
Exactly. I think that it needs to be, I would advise that if there's a financial penalty, that it needs to be a civil penalty. That's what the board is authorized to do, is issue civil penalties within the confines of what is authorized in the rule and outlined in the disciplinary matrix.
What's the maximum penalty for each violation or each complaint?
$1,000 per day per violation.
Okay, so there are 11 complaints that are, I guess we dismissed one, or were there 20? I'm sorry, this is number 12. How many were there?
Bear with me just a second, Rob, but I believe that there were. So I have 11 complaints against the firm and 8 complaints against the CPA, him or herself, although one of those is recommended for closure based on lack of evidence and support. You know, the other issue I think we need to be cognizant of as we go through this is that it is probably going to be a matter of years before his civil litigation is settled and before his federal criminal proceedings are settled. And I think the primary goal is to protect the public from this person's, continued behavior if she or he were to continue to engage on that. So to me, first thing is license revocation. Get him off the street or her off the street so that they're not using the name of CPA to take advantage of people anymore. With respect to the penalty, I won't be here 5 years from now at the time that he can apply for reinstatement if he chooses to do that. But if I were, one of the questions I would have before voting to reinstate is, what have you done to take care of the victims, that you have hurt? And that to me would be a factor I would consider in terms of whether, reinstatement should be granted or not. So I think there is a mechanism because that future board is going to have to consider the ramifications. We'll also know by then probably a little bit more about the civil litigation and whether he's in jail or she's in jail, what could be a long period of time. And so I'm also worried about the burden of trying to monitor over what could be a multi-year period what this person's financial predicament is to determine whether we will get our civil penalties paid or not vis-a-vis the victims. And so that's why, at least for me, I was comfortable not trying to levy a civil penalty in this case. But I do think in terms of victim restitution, that would be a factor that I would consider if I were a board member at the time that he ever applied for reinstatement.
I like the idea of leveling penalties that will not take effect if the person gives up the license forever, because close to what you said, I think it's going to be tough to get the whole gist of this case back on the table in 5 years and have the same perspective, because the people who saw it and who saw, who considered it would not be there. And so at least if there are penalties on the books, it represents the seriousness of it. And if we could simply get the person to revoke the license permanently, I think that would protect the public, certainly.
I would agree if we could do it, but I thought I heard Neil to basically say we're on thin legal grounds if we're basically pressuring or seeking a revocation period beyond 5 years.
Voluntary.
If he voluntarily does
it. Would be voluntary, right. So
yeah.
That's the difference there.
Okay.
Maybe. And I'm just giving you my best assessment here. And it says may suspend the license or refuse to renew the license. Renewal is different. License or 5 years was my recommendation. And essentially, it wouldn't be a revocation for life if he did the 5 years, but it would be the board would have discretion should he apply for reinstatement. Is that something that the committee is open to? Or?
If I could relay Larry's comment here, I don't think he does not believe the decision should be made based upon ability to pay or likelihood of collection. We need to be consistent with our other cases. We should assess it and then forgive it if he agrees to give up his license.
If he voluntarily surrenders his license.
Right, so maybe the question would be if that is the will of the committee, maybe we would have legal overnight look into the ability to stay a civil penalty if he agrees to permanently give up his license.
See if we can even say that.
And I think the leverage would just be that you're authorizing the hearing. If the committee is wanting, if the committee and the board are wanting to vote for life, then the question permanently. The question really. That's the case. I would just recommend if the committee is wanting to do that, revoke permanently, then I would just recommend that that's your recommendation. That is you authorize a hearing with the authority to settle upon the respondent agreeing to have his license revoked
voluntarily,
permanently.
Yeah.
There's no need to if the civil penalties are contingent. If you're willing to do that to give the civil penalty, as long as he revokes permanently, then.
But
the only thing that's needed authorize a hearing with the authority to settle upon the respondent's agreement to have his license.
Even if we don't assess such penalties here at this point. Okay.
That's what essentially the offer would be in that case would be authorizing a hearing with the authority to settle. So that's the offer is, look, respondent, a hearing has been authorized, but you have a chance to settle this by agreeing to have your license revoked permanently. And essentially what you're doing by that is saying, if you don't agree to our offer, which is agree to have your license revoked permanently, then we're going to a hearing. Range of.
Including the assessment of civil penalties.
Yes.
Okay.
My understanding is once you go to hearing, the offer kind of goes out the window, and then the board has the opportunity to assess whatever type of discipline they'd like, according to the law and the rules.
Whatever is within.
I'll again relay the next comments from Larry. In my 9 years on the board, this is one of the most egregious cases of non-professional actions. I think he would be much more willing to settle if he knows the amount of the penalty.
I think in the past, we've always listed the penalty. And I think it would be good to at least list a penalty here. But however, if he voluntarily surrenders his license, revokes it forever, then everything else will go away. The hearing, the penalty.
So the option could be revoked for 5 years and X amount of penalty, or forego the penalty and permanently revoke the license. Voluntarily revoke.
Mr. Chairman, I have a different perspective on this. I think we should assess a penalty, and I think, if I understood you correctly, Neil, if this goes to bankruptcy or whatever, the chips just fall wherever they may. But if I'm a victim of what we've read, I hold the Board of Accountancy somewhat responsible for assessing penalties against someone who's done this. And certainly if I'm a journalist and I can put a headline that this guy caused losses of $1.5 million, but his board of colleagues or Board of Accountants that consists of CPAs assessed no penalty against him, I think the press could have a heyday if we don't assess a monetary penalty. And I think that the penalty needs to be in the six-figure range, at least $100,000. We're talking about somebody who's caused losses potentially of $1,453,000, I think is the net number here. And then if we need to negotiate to have a permanent revocation, then maybe at that point we could decrease the penalty. But I think we need to impose a stiff penalty in this situation.
I don't know that we are limited by statute in terms of the amount of the penalty that we can impose. So I don't know that a six-figure penalty in this case would be allowable by statute. But I guess I would suggest this: why don't we give council and staff time this evening and tomorrow morning, or whatever time we can, to try to research that and determine at least what they believe the maximum penalty under the current existing statute and disciplinary metrics that we could recommend would be. And it sounds like there's a thread for still, though, offering to basically stand that penalty down in return for a permanent surrender of licensure by the respondent. Is that a fair summation?
And Mr. Chairman, when I said the six-figure number, $100,000, I was thinking of the per day, per incidence.
It just is it still going on? What is the per day?
Right.
It's ongoing. Okay.
Take that into account with research.
And I would say, if we need more time to bring this up at the next board meeting, would that be a consideration if we say we don't agree with this, we want you to come back? If I'm sitting here wondering how much time, I mean, there's probably a lot of things you have to go through the law on, and Duke may need more time to go back through and look at the number of days.
Yeah, I think that if you're talking about trying to tally up the number of, because like I said, on many of them, you've got maturity dates that have not been reached yet on the promissory notes. And yeah, payments have stopped, but that's only been, 4 months? And so I guess, yeah, we could probably give you an estimate up to this point where we are.
I was just going to say, because this is what I used to do in a prior life,
right?
And this is a very complex, and I'll just say mess. This is not just Tennessee. A lot of our complainants are from out of state, so there's a whole bunch that's going on there. And I think the way we always looked at professional boards from a law enforcement perspective is, what are you guys doing to handle the license? Because from a criminal enforcement perspective, restitution will be taken care of, and it's so new, and these things can take so long because you just have to unravel this massive web. Because we see like 1.6 million in losses, but some of these complaints are representing me. It's far larger on some of the boards that they're at. There's big complaint boards that try to get as many people to come talk to me as they're willing, but we have what we have. So this. We're kind of still in the early stages of this, and trying to do our best to kind of identify what this person did and take discipline against him. But this could take a while from either a civil litigation or a criminal litigation. It could take a while. These cases are not. It's just too much money, too many victims that you have to trace and track.
And that's another aspect of this, is that this all essentially came to light in September. It's now with the feds and it's now in civil litigation, but these matters are not nearly at any type of conclusion. Investigations of this magnitude for something like this typically take, I think, this could take years. So, the board may want to even consider a litigation monitoring here, because we don't have all the information that is going to be available eventually on this case. We have enough information, I believe, legally for me to recommend to you what I did here today and to provide you with the evidence that establishes probable cause. But it's no question that we don't have all the information. These investigations, as Duke has attested to, and in my experience, take a long time. And that's what I'll say.
Well, I'm reading the final sentence right here, and it says respondents voluntarily closed the CPA license. So I would assume that there's no way in the world he can open it back up, period, with what's going on. Is that a correct assumption?
No.
No?
I mean, if he requested to reopen the license, I'd have to reopen it.
And then the second part of that sentence.
He hasn't been disciplined.
Okay. And the second part is he's willing to surrender his license.
Which is right, yeah. Get surrender is that it's essentially the equivalent of revocation. And so that's where partly that comes into play with what the recommendation is that he is agreeing to surrender. So he went ahead and we talked, I discussed this with his attorney, and he went ahead and closed his license as an act of good faith, basically. And so he took the step to do that, but the attorney has also indicated that he's willing to surrender. So that leads us to believe that he would be willing to have it revoked, because that's essentially the same as. I don't think that we can say that just by his closing it that it has been surrendered. I think that would be more along the lines of revocation.
So is there a way to come up with a penalty per day to bottom owner? Because I think that if we can at least get a penalty out there with this, or voluntarily surrender or revoke your license, and not with a 5-year, but with I voluntarily revoke it, period.
I come back, if we were to levy something like a 6-figure fine or thereabouts, if it could be computed and permissible under our current statutes, and that's standing out there in the pecking order in terms of a bankruptcy resolution, along with all of the victims that are out there that are trying to collect, I would not want to be in front of those victims with that order. And I kind of go back, Neil, to your comment that if the point is to try to incentivize him to revoke it permanently, because that's our real concern, because 5 years doesn't seem like it's enough for what has been alleged, then I think we should just basically do that. It doesn't sound like we need a lever of a civil penalty to get to that point. If you all think we do, that's fine. But I think if we're talking about a fine of that large of an amount and it sticks, then we're depriving the potential victims of some recompense that they could otherwise get in their proceedings.
I would agree, and I would agree that we don't need a leverage of a civil penalty in order to get to revocation. We've got, should this go to hearing, we will be able to prove these allegations at a hearing.
Then we could assess the penalties then.
Yes. That's right. I'm confident that we will be able to prove, we will be able to succeed at hearing. Now, we may need to wait on further information to come in Again, we've got probable cause currently. We may need to wait on some further information to come in from these federal investigations that are going on. But I do not believe that we need a leverage of a civil penalty to get revocation here, because we've got the leverage of we're going to go to a hearing and bring these victims in to testify or present affidavits from these victims that you've taken money from them and not returned it. That's the leverage that I think will be successful in obtaining. I can't guarantee it, but I think we do have the leverage to get revocation here.
What about if we put to authorize a formal hearing where penalties after the hearing will be assessed with the authority to settle?
We can't say anything about what the board would do should a hearing occur, because that would be, you would have to deliberate. When I say the board could assess penalties at a hearing, I'm not saying that you have to or that there's a mandate to do so. And I don't think the board should make a determination now about what you would do should there be a hearing. I want to be clear about that too.
A way to imply that we will be considering penalties in our statement in case it's published.
Well, I think that it's that, he's represented by counsel, and it's in the law that at a hearing, the board has a number of options for discipline: civil penalties, suspension, revocation, limiting the license. So it's there every time the board authorizes a hearing. And y'all do that on a lot of different cases. You authorize a hearing with the authority to settle. That's kind of the thing that's looming over any respondent on these, is that, well, if I don't take this offer and it's not, let's say it's not renegotiated with the board, then we're going to a hearing. And so where frankly the penalties are going to be worse, could be, I'm not going to say are going to be. The board should not make any determination about what it definitely would do at a hearing. But the risk to the respondent is always, well, the penalties could be worse if you choose to go to a hearing. Because then it's not just going to be a $750 civil penalty or $1,000. It's going to be that times however many days you were in violation of the rules.
Is there any way to put that in the recommendation where we can say where we will consider?
Well, where they could be assessed up to a maximum of blah blah.
And I'm doing that so that the practicing CPAs will see it. I never thought about the news media, but I definitely want them to know. But I do think that this is the worst case I've seen since I've been in public accounting.
Typically, what we do is our letters to put in there. When I do a letter that a letter of warning. I do a letter that I put in there, not in the consent. It really wouldn't be appropriate to put it in the consent order. I put it in my letter that, should you refuse offer from the up to $1,000 per day per violation, and that's in the communication from my office to the respondent. So it's there. It's just not.
Well, I'm just, from my viewpoint, the recommendation and the committee's recommendation and the final board decision is public knowledge. So it's not in a letter. So they're not going to see the letter, but they're going to come back and judge us based on what's on the public. And that would be what we do here as a board. So can you form a suggestion of how we could word that so that we can imply that we really think this is bad, and unless you do this, there could be penalties also.
I'll have to give that some thought, because I don't know how else we would do that other than than what we put in there, which is that it will go to a hearing if you don't agree with this offer. don't know how we would put that into. Let me give it some thought.
Yeah. I get a sense from the board that we would like to reference some type of penalty. Is there a way, Duke, that you think that you can come up with a per day, per item up to this day based on the paperwork that we have?
That's the kind of volume you're talking about. If you're doing $1,000 per day on each one of those letters of credit, and default in terms of not paying that interest payment, and those that the principal is due, I mean, it's what the principal's past due. I mean, you're looking at a significant amount.
If we get into that large of an amount, I think we're really interfering with the victim's ability to recover, depending upon where that lies. Let me suggest this. Why don't we pull this item number 12 from our consideration at the committee level? In other words, we'll not vote on this one way or the other today as a committee, but we will give staff and legal a chance this afternoon and tonight to kind of work through things based on the comments that they've heard from the board members and committee members, and see if they have a recommendation for us as a full board tomorrow to address it, given the concerns and considerations that have been expressed all around, and move along that way, because I think that'll I think give a little clarity what we can do or should consider doing.
Mr. Chairman, I have just a comment or question for Neil, though, while you're doing your research. Is there any way, do you think, to agree on a revocation, but also to put this case in litigation monitoring? In other words, to potentially assess a penalty as a result of whatever we find through the litigation monitoring process?
To do that, you would just put it in litigation. Bit of revocation, I mean, it's not going to be monitored. It's going to be, that disposes of the case if he agrees to it and it settles for revocation. I just don't know a way to do both.
So is there comfort among the committee members for going ahead and separating out case 12, not acting upon that as a committee recommendation to the board today, but then letting the full board weigh in tomorrow on, hopefully based on whatever information staff and legal can come up with in response to our questions and comments? Okay. So we have items 9, 10, and 11. Are there any further questions or comments on the recommended discipline for those three cases?
And Larry had initially asked a question about number 11 and how we got to the $650 amount. And I will try to answer that. Legal can help there, but that is the new mitigating amount for that particular violation of practicing without a firm permit. The $650 is the mitigating violation on the discipline matrix, which is on the first page of the revised discipline matrix from the last meeting.
Yeah, I had that same question when I was doing my pre-review because the number was a little different. And then when I spoke with Neil, he indicated, well, that's now based on the higher revised discipline matrix amounts that the board approved in the revisions to the discipline matrix at its October meeting, I believe.
And Larry has acknowledged this.
Okay. Thank you. Any other questions or comments with respect to items 9, 10, and 11? If not, what I would do is offer a motion that we accept the recommended discipline for those three items. Is there a second?
I'll second.
Thank you,
Rob.
Thank you, Rob. Any further comment or discussion? Karen, will you please call the roll?
Evan Monroe,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Larry votes aye.
Greg Gilbert,
Aye.
Rob Vance.
Aye.
Thank you. The motion passes. And our last item with respect to the legal report is item number 13, which is a representation. This is a situation where there were a number of allegations regarding potential illegalities, including self-dealing, fraud, misappropriation of funds. The respondent has filed suit against the complainant, and the complainant intends to countersue. So other than confirming the active lawsuits, no other investigative steps have been taken. And that was the original recommendation, and it was to be placed in litigation monitoring. And that was placed in litigation monitoring in July of 2023. And at this point, there's little or no movement in the case. And so the recommendation is to go ahead and close it. However, with the proviso that the complainant certainly is open to filing another complaint once movement is taken and maybe the legal resolutions are resolved.
That's correct. And if any further information comes out of it that would actually provide substantiation toward the complaint, then the complainant could refile.
And the only question I have is making sure that the complainant knows that if we close this, that is still their option to do so.
We will communicate that to the complainant.
Okay. Any further questions on this one?
Larry's question is, why not continue to monitor since nothing has changed?
We can.
Well, so, but I mean, staff has recommended basically that we do close, and so maybe the ancillary question is, why are we recommending that versus continued litigation monitoring?
The complaint, it seems like the can may be being kicked down the road a bit. We were told that the complainant would countersue, and we were also informed recently that has not even happened yet.
Well, then you also say here the evidence does not establish any violation.
Correct. The current status of the evidence does not. That's right.
Right.
So is there any kind of overwhelming pressure or reason or rationale to close rather than continue to monitor? It sounds like the rationale is this could go on for years. And so therefore, if the complainant is aware and wants to file a complaint down the road, she or he may do so. That seems to be the primary rationale for closure at this point.
That's correct.
Okay. From the committee members or full board, any other comments or leanings one way or the other on this?
I would just
This is Rob. I would say close.
Thank you, Rob.
I agree with Rob. If there's no evidence there to suggest there's anything and the complainant has not come back at this point, I would agree with that.
I agree also.
Any further comment or discussion? If not, we'll go ahead and offer up a motion to accept the recommendation on the representation to go ahead and close this particular complaint, and with the knowledge that complainant will be informed of that and has the opportunity at any time in the future to file another complaint if she or he so chooses. Is there a second?
Second.
We have a motion and a second. Is there any further discussion or comment? Karen, will you please call the roll?
Evan Monroe,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Larry votes aye.
Greg Gilbert,
Aye.
Rob Vance.
Aye.
Thank you. The motion passes. And Mr. Chairman, that concludes the legal report. And I appreciate everybody's commentary and contributions to the discussion. Some of these cases are not easy to deal with for us as a regulatory body, and certainly also for others involved.
Thank you, Mr. Chairman. We appreciate it. Great job. Now we'll move on to the Executive Committee. And I will turn it over to Wendy to give us an update on travel.
Thank you, Mr. Chairman. The first item on the agenda is just an overview informational document on travel since the last board meeting. Or actually, this is October through November, and travel consisted of my travel to the NASBA annual meeting, and then an outreach event in Knoxville, and then Duke's travel to the board meetings, and then to a CPE session in Chattanooga.
Fantastic. Thank you. And thank you both for your involvement and reaching out and being a part of not only the TSCPA, but NASBA, because I think that's important as our board to have representatives there. Next on the agenda is our year-to-date or our fiscal year 24 financial results. So I'll let Wendy.
All right. Yes. Fiscal year 24, fiscal year 24. The fiscal period begins July 1st and ends June 30 of 24. The information that I've provided to you is for the period ending or year-to-date November. So I actually got financials a day or two ago for December. And so I'll comment on those after I kind of go through what I had already prepared. So far, as of the end of November, we've received our revenues at $219,785. Total expenditures are at $438,809, leaving us at a deficit of $219,024. Of course, renewal season. Licenses expired December 31st. The bulk of our revenue is within the November, December, January timeframe. So we were still waiting on quite a bit of revenue there. And I will say that we did have a robust December as far as revenue goes. So that will help alleviate some of my comments that I'll make here as part of the November financials. But as you'll note there, revenues were down about 9% to the prior year. That decrease I had noted was really attributable to a decline in renewals just happening later than we have seen in the prior years. And then we've had a slower number of initial licenses. So as some of you may know, with CPA evolution and some IT changes at NASBA, they really struggled in the back half of last year to get people approved to sit under the old exam before transitioning. Their volume substantially increased. They went through technology upgrades, which caused some problems with their systems, and some manual work needed to be done with candidates that were already in the system. And they had trouble getting us candidate files for folks that were done and ready to become licensed. And they really focused on the individuals that needed to get approved to be able to sit. And so with the volume that they had and the resources they had, they just got behind. So we did not receive the number of final candidate folders that we would normally see. And what you'll see on my executive director's report tomorrow, we only had 487 new licenses issued last year when we're normally at 600 or more. So we were down more than 100 new licenses last year. And I don't think that that's attributed to a decrease in the number of people wanting to become licensed. I think it's more related to this kind of backup that we saw. And that also January is usually a good month for us. And Karen advised me this morning that we issued, I believe, 75 licenses in January, which was a nice number in a 1 month period. So that's good information there. Salaries and benefits. So you'll see a noticeable increase there. This is really, you've heard me speak at prior meetings that there was a statewide effort to improve the salary structure and to make salaries at the state more competitive to the private sector. And so this has been probably a year-long effort. And that is noticeable in the salaries line item there, where we're up 25% to the prior year. And that's reflective of that. Also, raises, annual increases were typically done in January, and that has been moved to September. So you're seeing kind of a front end there of the raises that were given this past year. So we will not see that increase in January that we have seen in the past. As far as longevity compensation, that also is reflective of the bonus structure and stuff is paid out under longevity, which has already been done, and we used to not do that till January. So that's the significant increase there. Let's see, travel, you'll see a favorable variance there, and that's basically due to we had a fewer people attend NASBA's annual meeting, and then also we were able to get all of the NASBA regional meeting expenses booked in the prior year rather than the current year. So we're seeing we're fine there as far as travel goes. Employee training, you'll notice, is higher there, and that's attributed to some increase in the registration fee NASBA events, or more than we have seen in the past. And then also, Duke did attend that CPE session in December, so there were some CPE costs in there. And as far as cost backs, we are looking good there, so less of a concern, at least to this point, on cost backs. But I do expect with the additional revenue in December and January that we will balance out. I can't promise that we'll come out of a deficit, but we should look better than we do today. Any questions?
Questions for Wendy? All right, seeing none. We've also got the fiscal year 25 proposed budget.
Yes. So this is a proposed budget. The statute requires the board to approve an annual budget, so this will be an action item for the FY25 period. So this will begin July 1st, 24 through June 30 of 25. So I will walk through really each of these line items so that if y'all have any questions, we can talk about those. Licensing revenue, I am budgeting at flat to the FY23 period. This is the same renewal group of licensees that would renew. And I'm also budgeting conservative numbers on new licensees, mainly due to limited score releases this year. So I don't expect we'll have we had a huge bump this month, but I expect that to really level off due to the next score release won't be until April. And we'll have less folks testing, I believe, under this beginning of the new CPA evolution. Also, the prior actual revenue does include case and complaint revenue. So we always have that where we don't include case and complaint revenue in our budget numbers, but the actuals do include it. So that's the difference there. The state regulatory fee is a fee that the board has assessed, $10 for each individual license issued or renewed to active status during the time period. And then it's a $5 fee assessed for all active firm licenses issued or renewed to active status during that time period. That fee covers indirect costs associated with the department, including human resources, fiscal, and the commissioner's office. Salaries assumes a staff of 4, the executive director and 1 investigator. This is the same staffing plan that we've had historically for the past few years. It assumes a 3% compensation increase in September of 24. Pay for performance rewards and salary adjustments are typically implemented in September. And then I have attached a more detailed personnel budget. I sent you an updated email yesterday where I did add expense to the salary line item, mainly because we found out this week that the last part of the salary enhancement is taking effect immediately. And I did not have exact numbers, but somewhere between $10,000 to $15,000 is being added to the salary line item for our staff. And so I went in and plugged that number in which did increase that line item. It increases salaries as well as the employee benefit line item from what I had provided you late last week. And so the increase in salaries and employee benefits is roughly $130,000 increase in and of itself over the actuals from this prior year. Let's see. Travel is detailed in the attachment B. Travel, you'll see, is just a little bit over what we have budgeted for the current year. I did plug in a little bit extra there for Duke's travel back and forth for board meetings, as well as our actuals for board member travel to board meetings has gone up in the past year. So I just wanted to make sure that we had enough money budgeted for that. Communications and shipping is fairly similar to the prior year. I did add, taking into account we had a postage increase this summer. We also just recognized a second postage increase. So we are going to see a little bit of an increase in shipping costs. Third-party professional services and professional administrative services. This covers shredding, formal hearing expenses, collection agency services, and NASBA dues there, credit card processing fees. And if we were to implement a peer review oversight committee, expenses would fall there for that as well. I don't expect any significant changes in that line item. Supplies and furniture, general supply ordering. This includes food and beverage for our board meetings. And again, I don't expect much change in that area. Rentals and insurance covers car rentals when those are needed for travel. Awards covers any recognition items. Employee training, again, this is paid CPE for professional staff, and it also includes the registration fees for anyone attending NASBA meetings. Those registration fees have increased over the past year or so, and so I have added some monies there for that as well. So, and I've included, to make sure we have money there for Duke to attend at least one live CPE session during that time. Computer-related charges, those would be any technology-related equipment purchases. There's not much there because I don't expect that we're going to need much. Our computers are actually done through a contract and are done through cost backs. So that's would be our largest expense from a technology standpoint. State professional services includes our rent, IT supports tickets directly related to our board, telephone, printing services, and any services from the Secretary of State's office. So I don't expect a whole lot of changes there. We did see some savings there when we turned in the state car. So that was about $5,000 or $6,000 for the year that we will not see that expense going forward. So I feel comfortable with that. As far as year-end cost backs, this includes overhead from the Division of Regulatory Boards, including administrative costs associated with Assistant Commissioner's Office, legal, centralized complaints in the Customer Service Center. You will see that I, instead of that being one lump sum number, I tried to take individual areas and provide a number for those specific areas to try to come to a better number for total cost backs. And with the salaries restructure, that was obviously not just with our board, that's with salaries across the division. And so I took that into consideration with those numbers as well. That's probably the hardest thing to budget for is cost backs. But hopefully I got us to a reasonable number there that makes sense going forward. We have stabilized in our legal costs, which have been kind of all over the place, but spiked last year and always seem to spike when we have some turnover. But I think now that Neil's been with us almost a year, we're starting to see that stabilize from a legal cost standpoint. And so you will notice that I am proposing a deficit of $186,498. Which is not what any of you are used to seeing. Obviously, a significant amount of that is salaries. We also have a reserve balance of $1.6 million, which those of you who've been on the board for a while know that there's almost no way to spend that money. And in consultation with the department, we are comfortable with spending down that reserve through this deficit. We could likely do that for a few years before we seriously need to consider raising fees. And so I think we'll see how the current fiscal year works and how things look in the next fiscal year. And if this becomes a reality, then we at some point are going to need to talk about a fee increase.
Question along those lines, Wendy, and it may be from very dim memory, going back to the last sunset hearing that I participated in, but I think one of the metrics that the joint committee looked at was whether or not an entity was in deficit for consecutive years. Now, it looks like our FY23 was effectively break even. It was a small deficit, but is that a point of any concern, or is that covered by the fact that you indicated that the department at this point seems to be not uncomfortable with where this is running?
I do believe it is still, as you mentioned, a requirement that if you run a deficit for 2 consecutive years, that you do have to go to a self-sufficiency hearing in front of the legislature, and the department is comfortable doing that in this scenario, and I would be too. So,
okay.
Yes, we'll have to do that, but that's the nature of the process of oversight.
Okay, thank you.
Mm-hmm.
All right. Any further questions for Wendy? You, Wendy? I think that at this point we'll just step back and say, is there any other executive matters that we need to bring forth? I don't see any from our committee.
Larry has a question here.
Okay.
He said, am I assuming it, or is there a breakdown of revenue lines somewhere other than the narrative section? Would be nice to see breakdown of the $1 million. That has been those have been difficult breakdowns to get. And so we are working on that. And I believe the department is working on that, but I do not, Larry, easily have that number. A significant amount of it is renewal dollars. But we will work on getting a better breakdown of that.
All right. Thank you, Larry. Good question. Any other comments from any other committee members on the executive committee? Okay. All right. Seeing none, I'd say at this point we come to our public comment period. I would ask, is anybody coming in signed in?
If you could vote on the budget first.
Pardon me. At this point, we'll go back to the executive committee and ask for to approve the 25 budget. Do I have a motion?
So moved.
A second?
Second.
All right. All those in favor? Well, I've got a virtual person, so I've got to have a roll call. Thank you.
Andy Bonner.
Aye.
Larry Elmore.
Larry votes aye.
Greg Gilbert.
Aye.
Kevin Monroe.
All right. So the committee agreed to approve that to take it tomorrow to the board. At this point, I would say our final thing on the agenda today is for a public comment period. And I would ask, is anybody signed in, or are we seeing anything in the chat?
I do not see that anyone signed in, and we have nothing in the chat.
All right. Thank you, Wendy. So we will finish today. We will have a board meeting tomorrow on February the 2nd. And it will be our normal call board meeting at 8:30 in the morning, where we will give a summary of everything that we've done today, and then we have an agenda sitting out there for everyone to see. We also advise caution coming in tomorrow. I understand there may be some groundhogs sitting out there somewhere, so be careful as you drive in. But with that, do I have a motion to leave this meeting and go to the board meeting tomorrow?
Yes, so moved.
All right, guys, second.
Second.
All those in favor? Call.
Aye.
All right. Thank you, everybody.
Thank you.